Good afternoon. We will begin our program. Welcome. I am Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to welcome you to our annual Nies lecture on intellectual property. We are quite grateful that all of you are here for this occasion. Through this lecture series, begun more than 25 years ago, we remember the Honorable Helen Wilson Nies. The late Judge Nies served on the United States Court of Appeals for the Federal Circuit. Still today, more than a generation after her judicial service and lifetime, Judge Nies is recalled within the intellectual property community as a generous individual and a hardworking, accomplished, and modest judge. The suggestion of this yearly lecture came from one of our faculty in the 1990s. Today, our intellectual property program is led by Professors Bruce Boyden and Kaylee Murray, as for some time now, and together we have maintained this lecture and expanded our IP program. This year's Nies lecturer is Rebecca Tushnet, who serves as the Frank Stanton Professor of the First Amendment at Harvard Law School. A graduate of Yale Law School, she clerked for Judge Edward Becker of the U.S. Court of Appeals for the Third Circuit and Justice David Souter at the Supreme Court of the United States. She then practiced intellectual property law at Debevoise and Plimpton in Washington, D.C., before returning to law school as a professor. Professor Tushnet has wide-ranging legal and academic interests, including copyright, trademark, and advertising law, and she is part of the profession and the practice in a number of ways, in addition to her teaching and scholarship. For her Nies lecture today, Professor Tushnet has assigned herself the topic, The First Amendment Without Strict Scrutiny, Lessons from Intellectual Property Law. Won't you please join me in welcoming to Milwaukee and Marquette University Law School, to our legal community, Professor Rebecca Tushnet.
Okay, well, thank you so much for being here. I hope to leave plenty of time for questions. I'm going to start with just laying some groundwork. In terms of strict scrutiny, it is a standard by which the government must show that its actions were narrowly tailored to further a compelling government interest, and that they were the least restrictive means to further that interest. This standard generally applies to speech regulations that cover speech based on its content or its viewpoint, as opposed to neutral time, place, or manner regulations like limits on how loud a loudspeaker can be in a residential neighborhood. Regulations rarely pass strict scrutiny, but they can. And I won't be talking here about intermediate scrutiny, but a lot of what I'm going to say would apply to it too. With that background, I have a message that might be surprising. It certainly was surprising to me. Key strict scrutiny cases, which seemed like important pillars of modern First Amendment doctrine, might not be in place for all that much longer. So in Reed versus Town of Gilbert in 2015, the Supreme Court announced that strict scrutiny would apply to all content-based regulations, meaning that even non-censorious regulations, like those of a city trying to specify which signs can go where and for how long, they still have to show a compelling government interest, narrow tailoring, and that they're the least restrictive means of accomplishing the government's interest. Going back a little earlier in the Roberts Court, there was U.S. versus Stevens from 2010, in which the court held that legislatures can't create new categories of unprotected expression. On its face, the idea that no new categories of unprotected speech are allowed sounds compatible with a history and tradition focused test, but I want to go a bit deeper into the details. So Stevens involved a federal law that was enacted to make animal crush videos illegal. So these videos involve real animal cruelty, and they're often produced for sexual excitement. The Roberts majority said, as a general matter, the First Amendment means that government has no power to restrict expression because of its message, its ideas, its subject matter, or its content. The animal crush video was therefore presumptively invalid, or the animal crush video law was presumptively invalid, and the government had the burden to rebut the presumption. The court commented, though, there are historic and traditional categories that aren't subject to presumptive invalidity: obscenity, defamation, fraud, incitement to violence, and speech integral to criminal conduct. Those are well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. Those categories are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. However, the Stevens Court reasoned, that does not mean that governments can put other speech outside the First Amendment by determining that those other kinds of speech are also of such slight social value that their benefits are outweighed by their harms. Instead, when the Supreme Court found a category of speech unprotected in recent decades, it was not because of that cost-benefit analysis. Instead, the court found that sexual images of children, then known as child pornography, we'd now likely say child sexual abuse material, those were integrally related to the underlying abuse that produced them. Because the conduct involved in producing the materials was illegal, distributing them could also be made so. That is, the Stevens majority suggested that the prohibition of child pornography was not an extension of obscenity law, which requires that something have no social value, no literally artistic social value, and be offensive to community standards. Instead, the prohibition of child pornography was a variant of prohibiting speech integral to criminal conduct. It was like criminalizing an offer to sell drugs that are illegal. This reasoning has some problems of its own, including that it's not obvious why being able to suppress the creation of the speech means the ability to prosecute possessors or distributors of the speech who weren't involved in the creation, if you're reasoning from prohibitions on agreements or conspiracies to commit a crime. But the important point is that the court was unwilling to say that it was extending the logic of the unprotected categories, even if the speech looked category adjacent. Relatedly, the Stevens majority emphasized that although there was a long tradition of regulating animal cruelty, that did not equate to a tradition of regulating depictions of animal cruelty. Meanwhile, Justice Alito's Stevens dissent would have found, with no reference to history or tradition, that the law was constitutional as applied to at least some depictions of animal harm when it was illegal to harm the animal at the place of creation. He would instead have analogized to child pornography and reasoned that the creation of the videos was the economic motive for the animal cruelty depicted therein. So at the time, he endorsed a cost-benefit analysis that found the speech value of animal cruelty videos too minimal to outweigh the harm they caused. Now, perhaps Alito thinks differently about the First Amendment than the Second, or perhaps he thinks differently now that the court's composition has changed substantially, but it's clear that the dissent's method of reasoning in Stevens would have allowed many more new regulations of the relevant conduct than a standard requiring that new speech regulations have to regulate only the kind of speech that was regulated in the past. Meanwhile, as the composition of the lower federal courts has changed in many ways more substantially than the composition of the Supreme Court, some federal judges have begun to suggest that First Amendment doctrine needs to be reconfigured to focus on so-called history and tradition in line with what's going on in Article III standing and the Second Amendment. So in the last term, as I'll detail, there was a First Amendment Supreme Court case that gave no consideration to tiers of scrutiny at all, instead appealing to history and tradition, although not formally abandoning tiers of scrutiny. I'm going to briefly discuss a couple other areas where the court has moved away from a conceptual analysis to a history and tradition analysis, and what they might foretell about a similar move in First Amendment doctrine. So the obvious comparison here is Second Amendment cases. In Bruin, the Supreme Court told us that only gun restrictions that met a stringent historical compatibility test would be allowed. But of course, judges are rarely trained historians, and history tends not to speak in one voice. Therefore, the court is going to choose which period is relevant, as well as which regulations are not relevant, such as regulations in the frontier West that disarmed people when they came into town. And reflecting some of the resulting problems in Rahimi last term, a majority of the court found that its test did not require what it called a historical twin, but rather a historical analog. That is, you can't enact a gun restriction just because it would increase safety, and safety has traditionally been a key consideration in gun regulation, but you can enact a gun restriction when it is sufficiently analogous to past restrictions. This induced many people to ask, quite reasonably, what does a sufficient analogy look like? And I will just point out, it seems facially inconsistent with cases like Stevens, which did not explicitly allow a close analogy. So one answer is the sufficiently close analogy standard in Rahimi is a Goldilocks test. The analogy is sufficiently close when the Supreme Court tells us it is. It doesn't satisfy me, and of course it shouldn't satisfy you. The project of doing law, especially in a common law system, is to identify principles that might guide us, even if reasoned disagreement is possible. So there's some other legal doctrines that have grappled for somewhat longer periods with the question of how close a new rule is to an old situation. And Article 3 standing doctrine is my other comparator here. Standing might be particularly relevant to First Amendment questions because of standing's focus on harm. In recent years, the Supreme Court has also said that legislatures can't just create private standing for lawsuits in federal court unless the courts agree that Article 3's injury requirements are satisfied. That is, a plaintiff can't just show that the defendant broke a law that governed its conduct with respect to the plaintiff and recover damages. Instead, there has to be a sufficiently concrete harm tethered to that legal violation for Congress's creation of a private cause of action to be constitutional. The concrete injury test asks whether plaintiffs can identify a close historical or common law analog for their asserted harm, a standard that the court said isn't tethered to evolving beliefs about what kinds of suits should be heard in federal court. So we're done evolving the common law. We stopped at some point, and now we go no further. Based on those decisions by the Supreme Court, and as well as recent lower court cases following them, something that creates a non-zero risk of harm is probably not close enough to the harm itself to satisfy Article 3. So conduct that creates a risk of having your information, your private information misused, but doesn't involve misuse of that information is not enough to justify standing. A recent case says that conduct that creates a risk of copyright infringement, but only a risk, does not justify standing. At some point, the risk might well get big enough to justify standing, but a step down the road toward the risk of materializing doesn't seem to be enough, even if the materialized harm would create Article 3 standing. Likewise, in recent years, lower courts have expressed at least uncertainty whether unjust enrichment alone, the fact that the defendant benefited from its conduct, can confer Article 3 standing on a plaintiff who did not actually transfer or lose anything to the defendant. And of course, this is a rejection of realism and the harm benefit analysis that worked through most of the 20th century, but it is also happening, so we should acknowledge that. The standing cases are relevant to a potential history-based First Amendment, not just because the court's inquiry was historical, but because its reasoning on risk of harm has deep resonance with First Amendment principles. Even when we agree that a putative harm is harmful, governments may not be trustworthy in their assessment that particular speech causes a serious risk of that harm materializing. So as one famous First Amendment line goes, men feared witches and burnt women. So now I'm going to turn to lessons from intellectual property cases where the court has already leaned hard into history and tradition to reject First Amendment constraints on intellectual property rights. The first case has faded from First Amendment case law, but is poised for a big comeback. It's Zucchini versus Scripps Howard from 1977. Zucchini was a circus performer who was shot out of a cannon for audience delight. A TV news station recorded the entire performance and broadcast it as part of a story about the event. He sued for violation of his right of publicity, and the court found that his claim was not barred by the First Amendment, even though the incident was newsworthy. The court consistently characterized the conflict in Zucchini as one between the television station's First Amendment rights and the performer's interest in his entire act, since they did capture the entire thing and show the entire thing on camera. And the court said this is equivalent to a well-recognized common law copyright claim, even though it was labeled as a right of publicity claim. So common law copyright protected creative works before they were published, and for performances, it protected them against unauthorized fixation, including unauthorized recording. The court suggested that the use of Zucchini's entire act posed a substantial threat to the economic value of his performance, and the concern was quite specific to broadcasting the entire performance. The court emphasized that the broadcast of the entire performance, unlike the unauthorized use of another's name for purposes of trade or the incidental use of a name or picture by the press, goes to the heart of petitioners' ability to earn a living as an entertainer. Thus, according to the court, the state's interest in permitting a right of publicity claim is closely analogous to the goals of patent and copyright law. Lower courts then immediately disregarded the court's analogy and started approving almost anything under the heading right of publicity, including lawsuits based on people reminding audiences of a celebrity. So now you can be sued for putting a digital version of Manuel Noriega in a video combat game, or for using a blonde robot in a wig to imagine Wheel of Fortune in the future, or using the name of a company that also happens to be the name of the founder of the company. The California Supreme Court approved liability for an artist who drew pictures of the Three Stooges and sold them because he was making art for profit. That violated the Stooges' right of publicity. The Ninth Circuit held that using the on robot in the ad with the Wheel of Fortune violated Vanna White's right of publicity, and that creating a digital version of a football player in a football video game did too. So you might not care too much about the ability to evoke celebrities in ads, but you should care that the right of publicity now covers art. You should also care that the right of publicity covers reminding people of celebrities. For example, including a curvy brunette woman in an ad did allow Kim Kardashian to file a lawsuit against that ad. Indeed, given the expansion of the right of publicity, there is no existing doctrinal barrier to Donald Trump asserting a claim against truthful, non-misleading comparative advertising that compares Trump-branded Bibles to other Bibles, or offers to sell genuine Trump-branded meme coins on the secondary market, even though such ads would have to use his name to make the comparison intelligible. We could certainly make up new limits on the right of publicity, but not all lower courts are willing to do so, and new limits would make the doctrine more complicated and thus more likely to chill truthful, non-misleading speech, whether in or out of ads. So these expansions of the right of publicity were a mistake, and the historical analogy can actually help us recognize that. Right? Common law copyright in an entire performance is very different from controlling any mention or evocation of an identity in a commercial context. The analogy to common law to copyright could be used as a tailoring inquiry if we're thinking in tiers of scrutiny terms. So the current attempts to limit the right of publicity on First Amendment grounds often focus on two things: newsworthiness, a concept borrowed from privacy law, and transformativeness, a concept borrowed from copyright law. Those are both tailoring mechanisms. They try and limit the scope of the right of publicity in particular circumstances. But one question is, do they have a particular basis, either in history and tradition or the justification for the right? And the right of publicity as an interest dates only from the early 20th century. It started then as a ban on false endorsements. I would actually suggest that it can't be expanded beyond that and beyond banning reproduction of entire performances without breaking through key limits on privacy, false endorsement, and copyright law. But so far, courts have been very receptive to what they perceive as unfair free riding on a person's reputation. More recently, the court used history and tradition to reject two First Amendment challenges to the extension of copyright's term. First, by adding an extra 20 years to existing copyright terms, and second, by restoring foreign copyrights that had been lost in the United States because the foreign publishers hadn't complied with US requirements for claiming copyright. So the former helped Mickey Mouse and George Gershwin's music stay exclusive for longer. The latter restored copyright in some significant works, including The Lord of the Rings. Rather than analyzing whether these changes were speech regulations subject to intermediate or strict scrutiny, both of which were plausible, the Supreme Court didn't apply any particular level of scrutiny at all. Instead, it reasoned that term extension and creating federal copyrights, where none had previously existed, were both things we'd done before, including in the founding era, so no additional First Amendment analysis was required. In Eldred versus Ashcroft, the term extension case in 2003, the court emphasized that the Copyright Clause provides a robust foundation for federal copyright, and the contemporaneous adoption of the Bill of Rights and the Copyright Clause and the first Federal Copyright Act showed their compatibility. Further, the court pointed to fair use and the distinction between unprotectable ideas and protectable expression. So you can't have any copyright in facts or ideas. The court says that these are internal safeguards for free speech interests. So no external constraints are required, even though Congress added 20 years to the term of existing and future copyrights, delaying many important works from their scheduled entry into the public domain, where they could have been freely used by historians, artists, and everyone else. The Supreme Court then repeated the same reasoning in 2012 in Golan versus Holder, which is the restoration case, reasoning that the first Congress had allowed existing works to claim a new federal copyright. This was an appropriate analogy, the court reasoned, because copyright restoration gave federal copyrights to foreign works that had never had a U.S. copyright, a federal copyright, due to their failure to comply with the formalities that the U.S. used to impose on all works. So a work published abroad without a copyright notice would enter the U.S. public domain immediately, but it was okay for Congress to retroactively declare that no notice was required as long as no one was punished for their pre-restoration conduct. If people make new copies of these formerly public domain works, or if they make new derivative works, like recording an orchestra performing one of these works, so Shostakovich is one of the involved artists, they could be forced to stop doing that. Or if they've made derivative works, they can be forced to pay a court-determined amount for using them. The constitutional reasoning is Congress has long expanded copyright in various ways, as long as Congress acts within the traditional contours of copyright. That is, its acts require no further First Amendment scrutiny. This makes it pretty important to understand what the traditional contours are. But copyright has changed a lot since the time of the founding. It covers far more kinds of works, so the framers knew it as covering maps, books, and charts. That's it. So apparently extending copyright to movies and computer programs, and frankly, paintings and sculpture, well known at the time of the founding, is still within the traditional contours. So there's a little bit of analogical reasoning going on right there. In addition, copyright as the framers knew it only covered copying, as the name suggests. Congress then extended copyright to allow copyright owners to control many more acts, including public performance and creation of derivative works like sequels and translations, which were historically not within the scope of copyright. Implicitly, the court was relying on the label copyright and the claim that the covered works and the covered rights were sufficiently analogous to the traditional scope of copyright. But how are we going to know whether another extension is also sufficiently analogous? The court mentioned fair use and the idea expression distinction as key traditional contours. So maybe if Congress got rid of fair use or the idea expression distinction, that would violate the First Amendment. But Congress has passed laws that cut sharply back on fair use in the digital context. And lower courts, both before and after Golan, have said it's constitutional to prohibit circumvention of digital access controls, even if that makes many fair uses impossible. In addition, design patent is pretty clearly does allow some level of idea protection, even though design patent was also unknown to the founders. If your only guideline is traditional contours, and there's a history of contracting freedom to use expressive works, then it's difficult to tell when the traditional contours have been reshaped. And I want to mention things that might further test the limits of analogy. Right now, there's no copyright in laws. The Supreme Court has imposed this as a common law limit on the Copyright Act, even without specific statutory language setting it forth. So the laws of Georgia are free for everyone to copy and use as they see fit. There are currently proposals in Congress to grant copyright in laws and regulations if they were drafted by non-government actors. And in fact, of course, many, as we've seen with things like Project 2025, plenty of things that are issued by governments are drafted by private entities. It seems to me that any attempt to change the law, to make the law ownable by private entities, should trigger First Amendment scrutiny. But will it? Hard to know. More recently, trademark law has seen the same kind of untethered use of history and tradition, albeit without much consistency. So I'm going to talk about two cases, implicitly in Jack Daniels versus VIP from 2023, explicitly in Elster versus Vidal from 2024. Jack Daniels involved a parody dog toy that made fun of Jack Daniels. It was a plastic bottle with the label Bad Spaniels on it, and it squeaks when you squeeze it. The federal trademark statute lacks a general copyright-like fair use provision. Courts have instead created special tests for situations where greater scope for unauthorized use of a trademark seems justified. So comparative advertising, resale of used goods, and artistic references. Artistic uses have, in recent decades, often been judged using the so-called Rogers test. That's his name for Rogers versus Grimaldi, in which the Second Circuit held that claims against titles of expressive works had to meet a very high standard before a court could find actionable trademark confusion. So if you want to make the electric Kool-Aid acid test, go ahead. The Rogers test generally refuses trademark liability for an expressive work, regardless of evidence of confusion over whether it was authorized or sponsored by the trademark owner, unless the defendant's reference to the trademark lacks any relevance to the underlying work or is explicitly misleading. Some version of Rogers had been adopted by every circuit to decide the issue, and the test had often been used in cases involving for-profit but non-advertising speech. So when the New York Times put somebody's name or trademark in a headline, that would get you Rogers protection. In Jack Daniels versus VIP Products, the Supreme Court held that it did not need to apply or even decide the validity of Rogers as a speech protective test, so long as the defendant was using a similar term as a trademark to brand its own goods, and the court said that's what Bad Spaniels did. Trademark law's ordinary multi-factor test for consumer confusion does enough work to account for the interest in free expression in the context of trademark uses. This language, as others have noted, is very similar to its previous statement in Eldred that copyright law contains built-in First Amendment accommodations. But the analogy is highly imperfect. There's no trademark clause. There's no founding era trademark statute. Indeed, the court invalidated Congress's first attempt to pass a trademark statute nearly a century after the founding because it could not be justified under the IP clause. Nor would what current courts call likelihood of confusion be recognizable to certainly founding or even post-Reconstruction courts, or even really mid-20th century courts. They all protected trademark owners in far more limited circumstances. Until about a century ago, trademark law only applied at all in cases of passing off, where the defendant's goods would substitute for purchases of the plaintiff's goods. No one, no matter how drunk, would buy a bottle of Jack in place of a dog toy, or vice versa. So the court's statement in Jack Daniels that the multi-factor likelihood of confusion test, again, something that developed only in the 1960s, that it provides the only necessary protection for the First Amendment, thus lacks the explanatory apparatus it at least had in Eldred. So there's no basis in text, history, or structure for the contours of the doctrine, including the substantive protections of fair use. But more importantly, the announcement of the result, the confusion test provides all the free speech protection necessary, that's a poor guide for future cases, since courts are often willing to find confusion if consumers think that a speaker needs a trademark owner's permission to speak about a trademark owner. So then, in Elster versus Vidal, the court considered the trademark statute's blanket prohibition on registering a trademark that includes a living person's name without that person's consent. The Federal Circuit struck down this prohibition as insufficiently tailored to the relevant interests in preventing confusion and false endorsement. The court unanimously reversed, agreeing that the provision was constitutional even when it barred registration of a completely non-confusing mark, like Trump too small. Although the court was unanimous in result, it was unable to cohere on exactly why. The justices all agreed that the goal, protecting a person's right to control their use of their name as a trademark, was legitimate. But there were different views about what history and tradition counseled, and they said history and tradition is our guide. So should the analysis be at the level of the purpose of having a trademark registration system? Again, something that did not exist in anything like its current form until 1947. And previous versions were struck down and also not in any way used to create the kind of rights that trademarks now offer. But the court pointed out a registration system needs to make content-based distinctions to function. That is, to say that Xerox can be a trademark for photocopiers, but photocopier can't be, is to make a content-based distinction based on the meaning of the words. And if we're going to have a trademark system, that has to be okay. So, okay, registration needs to make content-based distinctions to function, but does that mean that any content-based regulation is okay? If that's the answer, then Congress could, for example, deny registration to any trademark that made reference to birth control or abortion. That would be a very broad analogy. So Elster says that trademark rights have always coexisted with the First Amendment, despite the fact that trademark protection necessarily requires content-based distinctions. So unsurprisingly, this is only true in the broadest strokes, right? Lots of things recognized as trademarks today would not qualify as trademarks in the founding era, or even really until the 1960s, like the shape of the Coca-Cola bottle. And of course, registration itself and the rights it creates was unknown to the founders. Still, I think it is true that at least some content-based distinctions are okay because of this history, but which ones? The court declines to tell us, and the concurrences are quite divided on what the approach should be. The opinion for the court relies on the long tradition of providing unfair competition protection to names in tort lawsuits brought by the person whose name it is. This is true. But the problem for the court is we also have a bar called 2A. It's a bar on registering marks that create a false suggestion of a connection with a person. It isn't obvious why the history would also allow 2C, which applies even, and in fact, because of 2A, only to a mark that wouldn't falsely suggest a connection because it's critical. So Justice Thomas's opinion for the court criticizes the other opinions for relying on loose analogies, but his own analogy is incredibly loose. The past case law is about misuse of names, so he can ban the registration of marks containing names without the referenced person's consent. The key move made by the opinion for the court is the acknowledgement that trademarks focus on source identification and its related focus on avoiding confusion over source. Those things rely on evaluating the content of the claimed mark, because that's obviously okay, right? Having a trademark system is legitimate, and implicitly having a trademark registration system is legitimate. The court says we need not evaluate a solely content-based restriction on registration under heightened scrutiny. That is, Justice Thomas implicitly holds that because trademark law requires a specific type of content-based regulation, confusion over source, it allows content-based regulation of trademarks in general. But the further problem is that 2C doesn't inherently have much to do with protecting the source-indicating function of a trademark. Barring registration of Democrats against Elon Musk and similar terms doesn't seem like it's going to facilitate source identification, especially when we already have rules against registering deceptive marks or marks that falsely indicate an association with another person or entity. So maybe the court means that Congress can make some content-based rules, not others. The opinion of the court adds in that the name restrictions have deep roots in our legal tradition. But Justice Barrett's concurring opinion does an excellent takedown of that logic, given that the deep roots are limited to confusing uses of names. So in order to justify the expansion to non-confusing uses, the court's opinion adds in that it's not just fraud that can be banned, but misappropriation, so-called piggybacking off another's name. Its historical foundation for that, though, comes from 1978, when Congress passed a law giving special rights to the U.S. Olympic Committee, hardly a founding-era concern, or Reconstruction-era concern, if you think that's relevant. Part of this is done by equivocation. Preventing fraud, the court says, means protecting the reputation of the trademark owner, which is at risk if someone else sells products under its name. Banning free riding also protects the trademark owner's reputation, the court says. But adding in you can't free ride off another endorses an expansion of rationale beyond deception. There's an obvious gap in the evidence cited by the main opinion that names were historically considered part of the trademark system, as Justice Barrett's concurrence pointed out, right? Refusals when the use isn't confusing are new. The historical evidence is all about controlling uses of names when the names were well known, and someone's copying would confuse consumers over the source of goods and services. And Justice Barrett notes that the ability to cherry pick a few cases out of the historical record allows for a lot of manipulation, especially in a common law nation where there's no such thing as an unbroken, consistent line of cases. Perhaps worse, what you do once you've found your past cases is even more important, figuring out whether the past cases are sufficiently like the present legislation. I want to make a specific point about relying on a founding era that had comparatively few laws and more reliance on judicially recognized causes of action to deal with a modern era of statutes. Because there's a category shift there, common law case-by-case adjudication sensitive to what's going on in a particular case, to lawmaking, making blanket rules that are designed to guide behavior in advance, making an analogy is much more difficult, but that difficulty is hard to notice because it sounds like you're talking about the same thing. Justice Barrett's concurrence in Elster criticizes the majority's bad historical analogies, but it has problems of its own. She'd be even looser in her requirements for historical justification. She reasons from the content-based nature of the trademark system that content-based trademark registration restrictions are permissible so long as they're reasonable in light of the system's purpose of facilitating source identification. And she also frames this as content-based criteria for trademark registration do not abridge the right to free speech so long as they reasonably relate to the preservation of the mark owner's goodwill and the prevention of consumer confusion. The issue then is that goodwill can be harmed not just by confusion, but by truthful information, as the current state of Tesla demonstrates. So exactly what Barrett thinks would be constitutional depends on whether she thinks goodwill is simply a shorthand for source identifying information, so that is the law and economics view of trademarks, or does goodwill include actual good reputation, including the non-factual aura and the sort of warm and fuzzy feelings that people have, in which case lots more things can be regulated. The point of my extended discussion of the conflicts within the different opinions is to point out that even if we say history and tradition is our guide, rather than a specific level of scrutiny, we have to answer key questions that follow. For things like bars on registering certain trademarks, should the analysis be at the level of the purpose of the specific regulation at issue, such as protecting personhood interests? Or should we care, for example, that denying registration to Trump too small is a very different thing from punishing the distribution of merchandise that says Trump too small to protect Trump's interests? One possible conclusion is that we've seen the history and tradition movie already in First Amendment IP cases, and it hasn't gone well. It doesn't supply its own analytic framework, and sufficiently close analogy doesn't turn out to be all that helpful. Where the court is striking down gun regulations, it is willing to contract First Amendment rights using historical rationales. The flabbiness of history, that is, works differently for different amendments. That should give us pause in further embracing history and tradition as a guide to the First Amendment more generally. I don't have solutions, but I have some thoughts about what might be coming. Based on past results, if a new right is labeled intellectual property, a holder of that right may be able to restrict others' speech even without showing any harm to themselves, as long as Congress doesn't engage in viewpoint discrimination in conferring the right. That's a very despairing take, though. It seems inconsistent with standing doctrine, and it leaves us with no guide to what speech can be made off limits to others through private ownership. There is an actual proposal, for example, to grant a permanent intellectual property right, copyright, to the American flag, to the US government. And the explicit purpose of this proposed legislation was to allow the government to ban flag burning, which the Supreme Court had said was unconstitutional viewpoint discrimination. So one question that we would still want to ask of proposals like the flag copyright, even without tiers of scrutiny, should be, does the speech restriction match well to the putative harm, or does it rely on an extended causal chain that could be interrupted by other factors? So I want to identify three comparisons that are easy to confuse, but perhaps profoundly different in their implications. First, the regulation at issue protects the same entity as previous rules. All the IP cases I've discussed have this form, but it leaves a huge amount of room to increase the amount of interference with others' speech interest in important ways. After all, the traditional rules did incorporate some balancing in their very enactment. That's how they had a scope, and that scope left room for other people to speak. Second possibility, the type of regulation at issue has the same name as previous rules. Eldred, Golan, and the proposal to give the US a copyright in the flag. This obviously has the same problem as the previous type of analogy. Finally, the regulation at issue protects the same interest as previous rules. This is clearly the most promising type of analysis, but it requires elaboration so that it doesn't have the very same problems as the previous options. Arguably, the court began the very start of this in the Second Amendment context in Rahimi, where it reasoned that the justifications for depriving domestic abusers of Second Amendment rights were the same as those for prior restrictions, once we started recognizing that women were as entitled to protection from physical abuse by intimates as they were from strangers, and far more at risk from it. The idea of focusing on analogies at the level of the government's interest in the regulation leads to my strongest conclusion. Although the tiers of scrutiny may be shaky for various reasons, the concerns they implement will not go away. In the First Amendment, those animating concerns are worry about government suppression of views it doesn't like, whether by viewpoint-based laws or laws that in practice discriminate against various viewpoints, a related worry about government's ability to identify when speech actually causes harm rather than just causing upset, and not unrelated but separate concerns about overbreadth and underbreadth, where poor targeting of a regulation may reveal bad motives or just unwarranted discrimination against certain kinds of speakers when other speakers or speech cause the same harm but are left unregulated. That is, considerations of fit, which are usually considered part of the second and third prongs of stricter and intermediate scrutiny, cannot and should not disappear even if compelling government interest and substantial government interest are replaced by a test that requires the government interest to be grounded in history and tradition. In fact, tailoring concerns are arguably the only way to evaluate whether newly enacted laws are consistent with history and tradition, where we allow some speech regulations but not others. Historical analogies can start us off, but we still need to ask about tailoring and the possible alternatives. We have these legitimate interests in suppressing certain speech, but we have to have a system for resolving competing claims when a new IP or other speech restrictive rule affects the ability of people to exercise the speech rights that they historically had. So Zucchini, the right of publicity case, could even offer us a potential model if we took the historical analogy seriously as a limit on what lawmakers can do, as we do in the Second Amendment context. So I believe that law should not be fundamentally unprincipled or unpredictable, even when some uncertainty is inevitable. So answering the question of how history and tradition could be translated into modern lawmaking is vital to the project of maintaining the rule of law, even in a time of rapid constitutional change. So I hope I've said enough sufficiently provocative to give us time for some questions. Please.
Terrific, thank you. So we do have time for questions. And if you would raise your hand, and I will recognize you in one sense or another, and we will try to make sure that we repeat the question if we're not able to hear it. So can you stand up and speak up, please?
Sure. Was a brief case was Stevens' case or both that involved the animal?
Stevens is the animal question.
We're just getting you going with an easy one there.
Okay.
Now Professor Boyden will get in, please.
So,
Well, just so that people can hear you.
so my question has to do with, so there's a lot in your talk about, the problems with history and tradition, the guys who, when are restrictions on speech, choose scrutiny on their own problems, right? So strict scrutiny, the regulation always fails. Rational basis, it always passes. Intermediate scrutiny, just I don't know, or how it strikes balance, right? It's government interest, all that important, and how does it balance that against the needs that's in most? So is that any better? Would you prefer over strict history and tradition?
This is a completely reasonable question, and I think let me say two things. One is, in some sense, no. What I want to tell you is that history and tradition will not solve our problems. So part of this is directed at people who are attracted to the current move, and I'm not telling them that they should reject that. What I'm telling them is they won't solve the problems with tiers of scrutiny precisely because parts 2 and 3 are always where the excitement happens. And, as Rahimi shows in the Second Amendment context, since we don't have flintlocks anymore, right, the law is going to look different. The question is, does that difference matter? And only fit of some sort. So the Europeans call it congruence and proportionality, right? Is the government action congruent to the interest asserted, and is it proportional to the amount of harm? Those are actually 2 and 3, not, but more like intermediate scrutiny, like they don't have a bias against accepting a speech regulation, but they're doing the same thing. And so one big message is, we will be doing the same thing, even if we say history and tradition is now the test. And then as for, is the shift justified? So this is a larger jurisprudential question, and maybe I probably can't convince anyone on this. I would say that the transition is gonna be pretty rough, because courts have not yet appreciated that even if they say history and tradition, they still need to do tailoring, congruence and proportionality, and they have no tools for that. And the benefit of the tiers of scrutiny is it actually told us, like, okay, is it, wildly overbroad? Is it wildly under-inclusive, right? Those are actually the helpful parts. Like, how much does this match up with the harm that you say you're regulating? The history and tradition only answers question 1, is the government interest sufficient? And turns out, in fact, almost no things that fail strict scrutiny fail at part 1. Likewise, nothing that fails intermediate scrutiny fails at part 1. So you haven't solved any of those problems.
Other questions? Yes, Nick.
You're right about saying the Supreme Court is not. It's not right because it's not last because it's right. It's right because it's last. Right. And so we, as a patent attorney, the patent attorneys in the room understand that when the Supreme Court gets involved in patent law, they always make big messes out of it. And it sounds like they're doing the same thing in trying to mix together free speech, First Amendment, when they try to mix together that with IP. But really, my question goes back to, can you talk a little more about the difference between history and tradition on the one hand and the common law on the other hand, because common law sort of sounds like history and tradition. And so I wanted to kind of hear more about what the differences and similarities are there.
So I have to say I'm going to be extremely critical here, because you've identified one of the key weaknesses of history and tradition, because one question you would ask is, okay, did they not regulate it just because it wasn't a problem? But if it had been a problem, they would have regulated it too, right? So this, for example, stuff, again, with the Second Amendment, high capacity magazines, right? In the founding era, you couldn't, they had speed loading, which meant, somebody could fire 2 bullets a minute, right? So, but they didn't have, nobody could have fired 100 bullets a minute, right? How are we to know what they would have done, right? And because history and tradition looks over a broader field than just common law cases, it has a bigger problem than just asking whether the common law recognized something, because you have to interpret the role of stuff that wasn't ever litigated, include laws that were enacted and laws that weren't enacted. So is there a history and tradition turns out to be a much harder question than what does the common law say? And then sometimes, unpredictably, courts say, okay, well, let's just look at the common law and see what it said. And of course, the problem there is, in a common law nation, the idea that you will find consistency out of the, 8,000 cases on the topic is not, that's just not, it's not an achievable goal. And the courts, so far, the Supreme Court has been willing to say, well, we've had a couple cases going this way, therefore there's no, consistent history and tradition. And that's just like, you didn't take enough common law courses in law school if you think that, right?
Other questions? Yes, please.
Yeah, is there a commercial speech overlay in regard to
dispensing with the tiers of scrutiny, specifically regarding copyright. So, I mean, does that dispense with the commercial speech?
So, in theory, if we were doing a commercial speech analysis, we would just be doing intermediate scrutiny and we'd have the exact same problem, since it's just like, then we just dial down the required government interest from compelling to substantial, and then we just dial down, 2 and 3 to is it reasonably well tailored, as opposed to narrowly tailored. So I think the answer is no. It's also interesting that up till 5 years ago, it sure looked like the Supreme Court was working its way towards getting rid of commercial speech and saying everything is strict scrutiny, even if it's a regulation of commercial speech. And now they seem quite prepared to go the other direction, that in the cases involving the social media regulations, where they were like, oh, I guess if it just regulates disclosure, it just needs to be is not enough to drive you out of business, and then it's fine, right? So I don't think we have any idea what's coming for commercial speech, but history and tradition would maybe give you a way to say, well, we don't need that category anymore because we just have a history of regulating commercial speech. Now we're done.
I think we'll take one more question if there is one. Okay, so we will take other questions outside in the Zilber Forum, which gets me to the first thing of 3 that I want to say. One is that there is a reception right outside in the Zilber Forum, and Professor Tushnet is, I am sure, eager to engage with other questions as well. So please join us for cookies and punch out there. Second, I want to thank all of you for being here this afternoon, or perhaps we regard it as evening. It's really inspiring to have such a wonderful and full room here for our Nies lecture on intellectual property. And third, I want to thank Professor Tushnet, who has some past connection with Wisconsin, but who traveled here from the East Coast to be with us and to deliver our Nies lecture. Immense thanks to you. Thank you.